Let me refer to your deposition, page 82, line 7. Didn't I ask you, when a bank employee determines that a borrower is in default, would you expect that bank employee to provide some written record of the default and the discussions with the customer or borrower about that default? Did I ask you that question?
You did.
And what was your answer?
Yes.
See, that would be the business practice, wouldn't it?
In looking at all the email communication, it appears that there were emails, there were discussions with the borrower. The borrower knew what was going on.
You discussed the issues, not you, Mr. Steger did, but again, a written notice of default is something that you never provided until November 17th. That's what you testified to, isn't it?
Yes, that is a written notice of default. Per the loan documents, the bank did not need to give a written notice of default.
Well, and I understand, now you're giving a legal opinion, but I'm asking again about your business practices. In your business practice, you'd expect the bank to say, hey, we've got an issue here, you've got so many days to cure, if you don't do that, we're going to declare default. That's what you would expect the bank to do.
I would expect whoever managed this account to work with the borrower and correct the issues at hand.
Well, let's take a look at page 76. Would you look at page 76 of your deposition?
I don't have my deposition, sorry.
Line 7.
Yes.
Did I ask you is that the standard process that you follow when there's a deviation from the loan documents? The answer was yes.
Yes.
And I asked you a question. You send a letter of deficiency notice. Tell the borrower what they need to do to cure the deficiency. Tell them the time they have to do it, and advise them if they don't, you're going to be declared in default. Is that the question I asked you?
That is the question.
And what was your answer?
Correct. We've essentially declared the default, and they have X number of days to cure that default before we take further action.
Then I asked you if they cure it, then you proceed with the funding of the terms of the construction loan agreement. What was your answer?
Correct.
Is that still your testimony today?
Yes.
You would provide a written notice of deficiency, telling the borrower you have a certain number of days before we declare default?
Saying they have X number of days, I don't think any of the emails gave them a specific time frame. The emails just asked for the information, the same information repeatedly.
You would expect, in this case, Ms. Steiner to make a recommendation of default, wouldn't you?
A recommendation of default?
Sure. She couldn't declare default by herself, could she?
The borrower puts themselves in default.
Well, the bank makes a determination, we're going to declare this loan in default, aren't they? Somebody in the bank has to make the decision, right?
So, yeah, someone has to identify that there's a default.
And declare the loan in default.
Don't know what you're asking me.
Well, we saw in the credit memo the approval process, right? Mr. Specht went out and filled out the application. He approved it. He sent it up to Mr. Yamtich. Mr. Yamtich sent it up to Mr. McCoy, Mr. Wilkins.
Yes.
And it needed those top-level approvals to fund the loan. And you need those same top-level approvals to declare it in default, right?
No.
Well, didn't you testify that Ms. Steger and Mr. Yamtich couldn't declare this in default by themselves?
I don't know.
Look at page 119. Sorry?
Which page do you want me to read?
119.
Okay.
Did I ask you at line 3, so Ms. Steiner and Mr. Yamtich could make a recommendation and put forth their case, but somebody above them would have to make the ultimate decision? Did I ask you that question?
You did.
And what was your answer?
The answer to that question was correct.
and I asked you a question, and would that be Wilkins and McCoy? What was your answer?
We're not talking about the same topic now. Your question
The
was-
ultimate decision of default. So I'm asking you, could you please give me your answer, and who would that be, Wilkins or McCoy? What was your answer?
Both. Wilkins is in the commercial real estate line of business. McCoy is in the credit side of the bank, checks and balances. But again, that's not the same line of questioning you're pursuing now. The original question was, could Ms. Steiger or Ms. Yamtich independently make the decision not to fund the loan going forward? No.
Let's go down to the bottom of the page. Do you see there?
What page, Counselor?
Still on 119.
Okay.
In your preparation of renewal documents, did you see any communications from McCoy or Wilkins approving the decision to terminate funding for the city center loan? What was your answer?
No.
And as you sit here today, do you have any knowledge that McCoy or Wilkins did approve the decision to terminate funding? Go to the next page.
Yeah, I said, can you ask that again?
Okay, and I ask you again.
Do I have anything besides no? I have no piece of paper to point to. I am confident if I called them right now and said, do you recall City Center and what went on, they would say, yeah, and decided to stop funding. There were issues. We weren't funding until these issues were cleared. They knew about it.
So, as the 30B6 who reviewed all these records, you didn't see any recommendation, written recommendation from Steiger or Yamtich up the food chain to declare a default?
No, I didn't see any communications with Wilkins or McCoy.
And you didn't see any records from Wilkins or McCoy declaring a default?
No.
All you saw was this November 17th letter declaring a default.
I saw repeated emails to the borrower.
So that wasn't my question. We've already covered the emails and issues. But the first notice of default was this, wasn't it?
Yes.
If the bank was declaring a default for the residential use, you'd expect a written notice to the borrower, wouldn't you?
Again, it was in the emails.
Are you talking about the May 19th email?
I'm not sure which email. There were a lot of them over the last week.
Would you agree that there's no email that's declaring a default for residential use?
I don't know. I know there's a lot of emails asking for leases.
You sat and listened to Ms. Steiger testify that, well, we're not saying we couldn't do it, we just wouldn't fund it. That was the gist of her testimony about residential, wasn't it?
Correct.
So even she agreed she didn't declare a default for residential use.
I know there were conversations between the bank and City Center about the residential use.
Well, what you know is based upon the documents, right? You reviewed the documents years later. You weren't part of any conversations.
No, I was not. But I do recall these conversations happening in the bank.
Well, again, you didn't administer the city sitting alone. You weren't there. Your knowledge is based upon the documents.
Correct.
There's no document declaring a default for residential use, is there?
I don't know if any one of these emails talks about the residential use or not.
Now, you talked about the covenants of the loan, but after reviewing all of these documents, it was your position that these only applied to buildings after the first building, wasn't it? You're going to build the first building in the front end, right?
That I know of.
Let's turn to page 172. Could you read your answer at the top of the page?
I'm going to object to the form. It doesn't pose a question.
No? Did you testify on May 14, 2009 under oath that, quote, the agreement on the front end was you would do the site work and build the first building with information we had in hand. To build a second building, they needed leases on both the second building and more leases on the first building. Is that your testimony?
That is what I said.
And do you stand by that testimony?
After reviewing this, I think I was wrong. I think we needed leases in hand before the first building started. The rest of it was accurate.
Your Honor, may we approach?